Good morning, ladies and gentlemen. You are all my future colleagues, and therefore, whatever I tell you today, you're going to question me tomorrow. So, I better be cautious about what I talk to you. From an entertainment perspective, in law, you may see a lot of movies which are coming out, which are blockbusters. You may speak and see about Salman Khan, etc. But in the back door, the legal team and the lawyers do a lot of work when you see a film which is released or a TV serial which is a hit. A lot of efforts goes on for the simple reason is that there are a lot of intellectual property rights which are involved, right from the signing up of an artist to the exploitation of the rights in India, globally, whether there are other claimants for that, whether somebody seems to have been defamed, all these issues come up which are prior to the release of the film. And the controversial part is that all these claims of 25 crores and 100 crores come up one day before the release of the film as a threat that you may get an injunction in the court and the film will not get released. Once you bounce off that release date, you will have several films which are lined up next time, and therefore you may not have some Fridays which are free. And therefore the commitment which has been given by your company to the broadcasters, to the theatres, etc. is all breached, and you're liable for compensations which are provided in that. In this scenario, there are lawyers and the legal teams in the companies which work in such a tangent that all these things do not come into the limelight, as when it becomes an issue in the newspaper, there are more controversies affiliated to that. So we all ensure that these are not basically arising out of such issues that it becomes a global conglomerate of the issues and your film and everything becomes a controversial thing. It takes a very less time in India to become controversial. Going on these challenges in the entertainment industry, as a law student today, apart from speaking very minorly, because my next speaker will speak about the IPR policies which are there, as a law student not aware about the practice side of the law, I will today show you the real pictures which are there in the courts of law and how we fight it, how certain movies become blockbuster like Dirty Picture, how good and bad they are to increase the work of the lawyer. In this scenario, first I will give you a gist about the IPR policy of 2016 which the government has given. Detailed discussion will follow by my co-panelist. Then I will tell you what are the present burning issues which are there in intellectual property rights. What kind of rights which are available. So we are now able to see a film also while traveling on an aircraft. That right also has a name which has been given to it. The original conception has come from United States, but in India also now it has become prominent, and that right is now recognized by the courts of law also. Then we talk about various issues which we face in intellectual property rights and what are the cases and judgments which are available to us in respect of the famous films, the recent films, which will give you a hint about it, that what happens on the law side of these intellectual property rights and how it is defended, and virtually nothing is seen in the media, and the TV serial and the film runs successfully and the issues are closed. Okay? The first point about intellectual property rights policy 2016. The intention of this government was that there should be an awareness about it. I think yesterday there was the seminar where criticism of this policy was given to you. One point of criticism which I read in the newspapers also, I was just reading the Hindu newspapers. where this particular criticism was given that the word awareness has been used in IPR policy of the government. I can tell you specifically how many times it has been stated. It has been stated 22 times. We have worked at the grassroots and the core level, and I can tell you there are certain big companies I've worked like Eureka Forbes, etc., where we have been talking to their senior management, and when we discovered that this component what you are saying about is a discovery, it's an invention, and it can be patented. So at that level, that kind of awareness was required. In India, in certain states, especially Gujarat, etc., you have some indigenous inventions which are so good, but there is no awareness whether these are patentable inventions or not. So the awareness perspective is from that point of view. When this water purifier was made, like you have this Eureka Forbes, Kent, now Unilever also is there in business. How this water purifier was discovered? The patent is, the holder of the patent is a person staying in Mumbai, Andheri area, if somebody is familiar with Mumbai. This person is the holder of the patent of a water purifier. This particular invention was discovered when there was flood in a place and there was no drinking water available, and this gentleman provided a social service by giving out this patented item, which gradually now we are seeing as a water purifier, AquaGuard, etc. So these types of awareness which are not available. Second, what the government is doing is that today, if you go to copyright registry, I am telling you the fact of life which you are yet to face. If you go to copyright registrar in Delhi, there is only one registry. Like trademark, you have multiple registry. You have in Bombay, you have in Ahmedabad, you have in Delhi. In copyright, you have only one registrar where you have to file all your applications. So in the lawyer fraternity, what do you talk about that? You say that you are filing a copyright application. Will you get the registration? 10 years down the line, the applications are still pending. Why do people file copyright applications then? So that if somebody infringes your copyright, then you can go to the court and show them that on 30th July 2016, I filed this copyright application. I am prior than this person's application, or this person has not filed, and this application only helps me to get an injunction in the court of law. Copyright registration does not happen. It takes around more than 10 years to do that. In trademark, normally the government used to take 18 months to issue an examination report. Briefly, I'll tell you what is the stage in trademark. You file an application. There is an examiner of trademark who sees, all right, is this a common name? Is this a generic name? Or is it something which you have coined? Based on that, he will issue a letter to you after 18 months of application, where there are two criteria which you will read in your Trademark Act. The trademark should not distinguish, should be distinguishing, and should be XYZ. There are only two criteria. When you receive this examination report, you will have a laugh, because he will tick mark on both of them, even if it is a coined word. So when I apply Reliance, I can understand there is a commonality in that word. But when I apply for Zapac.com, which is a coined word, how is my trademark a generic? So after 18 months, you receive that. What do you do after that? Within a month, you reply citing only two case laws. One is Sun Microsystem versus Sun, saying that, see, if this particular Sun word can be used and if an order has been given by the court, what is the problem with my mark? You pull out the records of 10 years of application, you will find only these two case laws which are printed and signed and submitted, and lawyers issue a bill to you. After you do that, the next stage is that the examiner will call you for opposition hearing or hearing you on that matter. That particular hearing will come approximately after 6 months or something. So 2-3 adjournments will be given because there are a lot of files, you are not the priority in life. After that, you go for that hearing, then an advertisement before objection is filed, which is a mandatory 3 months period in the law, that even after examiner clears that, within 3 months somebody can object that. Okay? Some notorious fellows always check that and they always oppose you. After that you are granted that. So the whole process used to take around 5 years. What the government is saying is that once from the examination stage to the receipt of the trademark certificate saying that your trademark is registered, it should take only 1 month. I think it's a great move because we have seen all the bad days. This is something too good for us, and I think these kinds of policies should be appreciated. Number 3, government is saying that certain cancer drugs which are available in the market, which are patented products, which are costing 20,000, 25,000 something, will be available to you under compulsory licensing, which is section 3D of your Patent Act, which says that these drugs can be manufactured by generic drug producer at a lower cost, and therefore the cost of the drug will be around 2,000 to 5,000. I think it's a great move. So all these things are there. And the fourth last thing government is talking about is IP commercialization. Anybody have heard about World Intellectual Property Office, what my certification was told about? So there is a body of United Nations, World Intellectual Property Office Academy, which offers you courses in intellectual property rights. They talk about IP monetization, IP commercialization, and IP valuation. I am not talking about IP valuation of Kingfisher, because that was on a different level. This is a genuine IP valuation where you talk about Coca-Cola or where you talk about companies like Tata's, where there is genuine IP valuation. Government is saying that you can now use IP as a commercialization for financing purpose. So all these are my 4 observations, and I think IPR policy is a good policy. Reducing timelines not only in IPR but in courts of law also will make a lot of difference to us. Okay? With this summary of IPR policy, you will have a detailed session on that by my co-panelist. I'll now proceed to the challenges in entertainment sector from the perspective of IP and law. Alright? So this is what we are going to discuss. At the later end of the time, you will have a gala time because we are going to talk about some controversial songs, etc. First, initially, we'll talk about some academics, which is also made interesting for you. We'll talk about some burning issues in copyright. Okay? See, as a law student, you may not be aware of what are the discussions which are going on in the government, why certain laws have come into force, who's responsible under the law and all that. So we'll first talk about burning issues, then we'll speak about the complete rights which are available in intellectual property rights to you. IPR ecosystem, this is from the World Intellectual Property Office Academy of United Nations, which speaks about IP commercialization, which now the IPR policy of India speaks about. I'm just giving you a gist about it so that knowledge-wise you have 100% to it. We'll then talk about what are the major laws which are applicable when you're dealing with an entertainment industry, issues in entertainment law, specific dispute areas. Then you have your famous song of Ooh La La, The Dirty Picture. You have a landmark judgment of the Bombay High Court on the name The Dirty Picture. You have an example of a film, Lutera. You have an example of a film, Shootout at Badala. And there are 2 serials, there is one more film, Ek Thi Dine, and one more serial, Jodha Akbar. These are certain cases, real-time cases, which I will put before you. Alright? So you have academic as well as practical knowledge about it. So there was an amendment in the copyright law that royalty is payable to the musician. This particular issue became very controversial. It was in newspapers. The industry went against Mr. Javed Akhtar. I met Mr. Javed Akhtar personally to discuss this issue, and we went to the copyright registrar on these particular questions before the law came into force. What burning issue in copyright law is that there was an amendment in the copyright law that royalty will now be payable to the singer and the musician and the lyricist who writes the song. What is the royalty? That a copyright society will be formed under Copyright Act. They will decide that. What is the controversy? The film industry says, if a singer, Sonu Nigam for example, sings a song for me, I pay him 5 lakh rupees. He signs on the dotted line, the song belongs to me. I may exploit it with a television channel. I may use it in a Filmfare award. I may do whatever I want. He has no right or say in that. Okay? This was going on since beginning in the film industry. What this law says is that if you exploit this on television channel, whatever you receive from television channel, 1 crore, 5 crore, 10 crore, 50 crore, certain percentage you will have to give to Sonu Nigam again and again as many times you exploit this particular song. The film industry was shocked because they have not budgeted that. When you nowadays make a film, your film budget itself is 80 crores and 100 crores. If you start keeping provisions for all this royalty, then your cost of the film will become 150 crores, and sometimes it will not be feasible. Because every movie is not a hit movie. You may have 2-3 exceptional actors which are giving you hit. Other movies don't make up to the cost also. So the question which was asked is that whether Balaji Telefilms, which makes a film Dirty Picture, will have to pay Sonu Nigam, who has been signed by me, whenever this particular song is exploited. The copyright registrar clarified that it is the person who exploits that particular song will have to pay. Which means if ZTV is showing that particular song, they will have to pay the royalty to Sonu Nigam. If the theatres are showing the film again, they will have to pay the singer. Now, this is what is the amendment in the copyright law. This is a burning issue, and that is why if you see the IPR policy 2016 released by Mr. Arun Jaitley, he says now onwards whatever copyright issues are there, I am transferring that from the copyright registrar to the DIPP department. Okay, this is an investment department which takes care of IPR issues also. So this is one issue. The second issue which came up is that can I waive this particular royalty? You sign all types of contract. I say that I have given Sonu Nigam 5 lakh rupees. 2.5 lakh rupees is his professional cost. 2.5 lakh is towards full and final royalty payable lifetime. Can I do that? Because as a lawyer we think of many ways to how to turn by the law. The Copyright Act says it very clearly. Even if the singer signs an agreement waiving off that right, the law says that particular clause is null and void. Which means, even if Sonu Nigam has signed such agreement, in future, if he issues a legal notice to you saying that this is the royalty which is pending, please pay, you are bound to pay because that clause in the agreement is considered as null and void ab initio. Okay, so these are two burning issues. We have one more burning issue which is going on. not related to IPR, but just to give you a sense about it, because we're talking about entertainment industry, is the fight which is going on for the theatres. There are two films which have faced this controversy. One is Son of Sardar versus Jab Tak Hai Jahan, in which Ajay Devgan had gone to Competition Commission of India saying that Yash Raj, who are the producers of Jab Tak Hai Jahan, have conquered all the theatres and I am not getting theatres for exhibiting my film, and therefore this is dominance and therefore this is violation of Competition Act. That particular complaint has been dismissed. At some point of time, these authorities will get into that. These are presently the burning issues which are there in the industry. Alright? Now, what are the complete rights which are available in an entertainment industry? This is very informative because you may be aware of 2-3, but this is how producers really make money. You have these 18 rights which are sold whenever a film is made or whenever a TV serial is exploited. The first right is an airborne right. Airborne right means whatever you see while traveling in an aircraft, the rights of that particular given by the producer is known as airborne rights. There are some clip rights. For example, certain on YouTube or something, there is some use of an Audi car in a film. Now Audi gets into an arrangement saying that, whatever you have made this position in the film, I want to use this clipping and also advertise my product. This is known as clip rights. You have derivative rights where you have movie translations, where you have book converted into a TV serial or films. You have hotel rights, that is use of your intellectual property rights in the hotel. You have musical publishing rights, non-theatrical rights, online distribution rights, PPV, pay per view. Tata Sky is an example of that. So whatever you pay to Tata Sky for viewing a movie is known as PPP rights. Print publication, radio rights, satellite rights, ship rights, soundtrack recording rights. Recent example of soundtrack recording rights is the movie Azhar. Because in that movie, when Azhar was portrayed, at that time Sangeeta Bijlani was doing the movie Tridev, and therefore that particular song has been used. Surface transport right. What is surface transport right? When you travel by a bus and the bus is a video coach, even that rights are subject to contractual exploitation. If any person or transport company is showing it without the rights, it's in violation of the intellectual property rights. You have video on demand, next Netflix, Big Flicks which are coming up. You have video rights, you have television rights, and you have theatrical rights. Theatrical means your theatres. Okay? So these are the complete rights which an entertainment company exploits, and money is earned from these rights. This is very important knowledge for you, as our IPR policy presently speaks about IP commercialization. I just wanted to give you a hint about it because there is a mention of this in World Intellectual Property Office academic curriculum, and these curriculums are futuristically made. Like for example, in 2002 we used to discuss that one is intellectual property rights, one is alternative dispute resolution, and one is cyber laws. These are one of your futuristic laws, because all your civil and criminal laws are settled. These are all futuristic practices, and today we are seeing those things in life. Intellectual property rights ecosystem. What do you mean by an ecosystem? These are the three things which you have to remember. Whenever you will be advising any company or you will be representing any company, you will have to first speak about an IP creation. So a film is made. Before a film is made, there is a script which is there for the film. Now that particular script requires registration, because otherwise you will face examples which I'll give you in the next slide of Ekta Tiger, where Yash Raj film and Salman Khan were there. but the script had an issue about it and it has become a big issue now. I'll give you an example in the next slide itself. When your IP commercialization, when you're giving your distribution right to your distributors to show it in the theater, when you're giving it to ZTV and Star TV to show them on the television, there are boundaries which are available. You can give it for India, you can give it for Asia. So for example, ZTV is available worldwide. So there you have to define your right. If you miss out, it is assumed that it is given in India. But if you specify globally, then you can't create a parallel right. Alright? And the third point is IP enforcement. These are the 3 points. In fact, IPR policy also speaks about IP enforcement. So we should be grateful to our present finance minister of having incorporated things which are provided in the World Intellectual Property Academic records. And the present finance minister also made a statement that these are in compliance with the WIPO requirements. Therefore, these things futuristically is very important for you to also guide your clients and in your practice. When you speak about IP creation, it's about your film script. You have to ensure that the script is not copied or the IPR does not belong to a third party. The example which I have given is Ekta Tiger. What happened in this film is that a gentleman went to a police station saying that, the script of Ekta Tiger, where you have Yashraj film, one of the biggest banners, and Salman Khan, this script is a script which is made by me. I have all formal registration which are available with me. So initially, by the good office, the police was taking cognizance of it. This gentleman landed up in the courts of law. He says, I have registered this script with the association. I have the copyright which has been available for this particular script. I have filed for copyright application. And therefore, it's a clear case made out that this is a copied script and therefore I should be given damages. In today's world, when a film is released, we start calculating 100 crores and 200 crores, and therefore the claim of damages also was made 50 crores. Prima facie, we have seen the case on the merits. The script looks like being tampered with. The script looks like that's a very similar script of this particular gentleman. Finally, under the directions of the court, a criminal case for infringement of copyright has been registered against Yashraj, and this case is still going on. Therefore, the caution of registration of the script and ensuring that you have all the registrations before you proceed to make a film. Your next stage is about IP protection. So whenever you have a script, you go for every registration which is available under the sun. You have copyright applications filed. It takes 10 years, does not matter. Have the registration in place. There are certain norms in the TV and film industry that there are recognized associations, and these associations are very strong. Even if an actor does not report on time and you complain to that, these associations are very powerful. Registration of the script with the association is one of the powerful things, and in one of the issues, when a film was to be released on Friday and Thursday a legal notice was received, this association itself has saved that particular company, which will come in my next slide. IP commercialization. Whenever you go for IP commercialization, you will be having a global distribution. You are not restricted to India. You have audiences who look out for your films even abroad. Ensure that you have proper agreements in place. You don't have conflict in the agreement. Because these are all the normal scenarios we have seen, that one person has given right globally and then an African producer approaches this production company. He says, I'll give you 50 crore. We sign the agreement and give it to him saying that money is coming, but when you have given global rights, it includes Africa also. So those are all issues we have seen through. IP enforcement, a fantastic example, which in detail I will take it in the issues also. Previously, the problem with the film name was that the film names are not trademark. Film like Don, a common name. So you have one Don which is of Amitabh Bachchan, you have one Don which is of Shah Rukh Khan, you have also South Indian actor Nagarjuna's Don 1. So how do you ensure that even your film name is a brand name and has become famous? How do you stop exploiting that? You should give thanks to Balaji Telefilms. Bombay High Court has now passed a judgment that even a film name is a brand name and therefore you can't use that particular name. I'll give you the case details later on. We had fought this case on the basis that even the name of the film is published in the newspapers in the ranking of a brand. How can you not recognize film name as a brand? Okay. These are some guidances you have to follow as a lawyer. You will have to advise your client on some infringement which you have to take care. So when you work for a production company, you can't send video clips by email because it may be your promotion material, it may be some confidential data. So those kinds of restrictions are there. Ensure that everything under the sun, whatever you do in an entertainment industry, is registered with some authority. So your brand name is registered with the association, you file a copyright for that particular brand name, logo, etc. Ensure all registrations are in place. You need to have a strong technological backup. Today we talk about piracy, but do you know the piracy part has now reduced? Because there are new businesses which come up, there are agencies which keep track on the websites. So for example, Kabali film which was released recently, one of the website Torrent, which is well known for all piracy stuff, this particular website had to remove Kabali film because there are anti-piracy organizations which have now come up. They charge you, they are under contract from you, and they keep monitoring all these things. Okay? Ensure you have proper documentation for each rights. So if you have given certain rights like you can use my name, you can use this particular music, have defined rights and clear-cut agreements so that there is no conflict in the agreements. Okay. So this is about the academic part of it. Major laws which are applicable to the entertainment industry: copyright and trademark law, Cinematographic Act under which you get your certification, Animals Welfare Act, when you use animal in a film, your certificate is required that no animal were harmed, etc., which you see in the disclaimer. Cable TV network and regulation, Ministry of Information and Broadcasting, CBFC guidelines are there. So for example, when you see your news channels, if a murder news is shown, you will typically observe that the blood is not shown because that is one of the guidelines, that you can't show blood on the television. Okay? You have tried TV side guidelines for broadcasting. This is for your satellite rights where films are shown on television channels. So for example, Dirty Picture had to be re-edited before it was shown on Sony TV. Alright? I have not taken that example in my slide, so I'll tell you what happened with TRI for us and Ministry of Information and Broadcasting. So there was a lot of demand that the Dirty Picture movie, little controversial on the fact, television rights for this particular movie was given to Sony Channel. Now, if the movie is controversial, the certification authority will re-edit that for television viewing purpose because there is no control on the age bar. Now, we had shown it to the certification authority. They said, okay, alright, you can go ahead and do that. And then Sony TV was to show it on some Sunday, a year back or 2 years back. Saturday night at 11 o'clock, we receive a fax from Ministry of Information and Broadcasting saying that please stay the broadcasting of this movie immediately and comply with the order forthwith. One right which I had is that I had a green signal from the certification authority and I would have gone and showed that movie. The second problem is that if I show that movie, edited form or non-edited form, my legal department is going to get hundreds of PIL as a norm. What we did as a seasoned decision is that if a government authority has given an order to you, comply with that. It's not about showing this Sunday or next Sunday. Comply with the order, satisfy the government and then proceed with that. We did that and I think immediately within next week or 2 weeks we could show that movie. You have Contract Act. This Contract Act is very useful because when you sign up movies, you have a star list who charge you a lot of money. In today's world, what has happened is that every A star wants to become your co-producer without investing money. So for example, today if Akshay Kumar signs you up, he will charge you 40 crore rupees. He will say if the film makes more than 70 or 80 crores, I will take 50% share in that. And then he will have some share in the global exploitation. Okay. From the contractual point of view, your bargaining, your agreement should be so sharp that you don't create certain rights which land up giving money to other people instead of earning that money for you because you are the person who has invested. A producer is an investor and therefore he expects a return for money. You have Indian Penal Code. This particular law is applied for all the criminal offences which are filed. So for example, when we had movie Shootout at Lokhandwala or Shootout at Wadala, we had all types of notices which were served, we had all types of criminal cases which were served on it. One example which I have not taken in the slide is about Shootout at Wadala. Shootout at Wadala is about a person who was not a criminal, he was one of the top ranking student of the college who entered in the field of crime and who was finally shot by the police. This is the short story about it. There are proven facts, we had documentations, we had everything before the film is made, you have all the police records, even the concerned police officers are involved for your initial stage of inquiry. I am sent a legal notice of defamation by the brother of the gangster, saying that you have disreputed my brother. And then finally a defamation case is filed. So we fight it in the court of law, but these are the real scenarios what you get when you disrepute somebody who is a gangster. Now we see the real issues which come up in the entertainment industry from the legal perspective. Apart from IPR 90%, 5 to 10% I have also taken some social economic issues because as a lawyer you will face these issues in your real life. You will get all these defamation notices, you will get all the political threats, you will have political parties which are ramming up because when you create a controversy in the film you get more publicity. So you get all these issues and therefore today I want you to face this real life so that tomorrow you are ready for that. There are categorically two issues which you face in an entertainment industry which are all related to content. One is about intellectual property rights, primarily about copyright and trademark infringement, etc. And the next is about issues of morality, decency, sentiments, your social and cultural issues. Okay? Now your first dispute area is about copyright. So most of the legal challenges surround the copyright infringement of content in film, TV and music. For example, you have copied my story, you have copied my script, you have copied my music. The second issue you get is about passing off or trademark issues. If you see nowadays serial, the television serials which are there, if you see the actor who is holding an iPhone, you will categorically see that the logo of Apple is particularly blocked, because these companies do take cognizance about it. So these are issues. This is your dispute number one of passing off and trademark. Certain companies don't take action. Reason for that is that you're getting a free publicity about it. So you have issues about name of the film, you have issues about product placement, you have issues about marketing deals which are happening. So I've given one example, Audi car shown in the car without permission of Audi. Okay, so whatever material you see in the film or a television serial, especially films, these are all materials for which prior permission is taken from those companies, because otherwise immediately a notice is served. I remember, I have not seen that film, there was one version of Kya Super Cool Hair film where you have Tushar Kapoor. In that film, some magazine is shown, some magazine speaks about, I don't recall, Playboy, sorry. The Playboy magazine is shown. I have not seen that movie, but I received the legal notice and that is how I came to know. So magazine Playboy was shown. So normally what happens when your film is completed, there is a team which looks to every nook and corner and to find out, are we infringing any trademark, copyright on anything. Somehow this got missed in it, and this particular Playboy magazine was shown. I received a notice from Zia Modi AZB Partners saying that please cease and desist, otherwise my client will be constrained to claim crores of damages. I know her personally, but I also feel that sometimes, see, this is a cease and desist notice. So we immediately removed it from the film. However, the law firm would have made a lot of business out of that. So I spoke to her about it also, but they're big clients, they're interested in issuing a cease and desist notice so that you don't repeat that particular thing. But this is all good companies do take cognizance about it. If you show Coca-Cola without permission, you will have a legal notice lined up with you. So you have to be very cautious when you do anything like that. Your third dispute area is about your morality, decency and sentiments. You have decency, you have nudity, obscenity, vulgarity. You're hurting sentiments of any religious community or community at large. You are showing atrocities, riots. You are disrespecting scheduled caste. You are insulting to the flag of the country. You are promoting communalism and all that. These are all punishable offenses under the law. You will have to guard against that. Okay? Now we see examples of intellectual property issues. The first example I am taking is from the movie Dirty Picture. You have this very famous song Ooh La La, which became very famous. There is a case pending in the Kolkata High Court that this is a copy version of some other song which now has become famous because of this song. So Saregama, old music company, has rights of a song known as Uy Amma, which is also sung by Mr. Bappi Lahiri only, and Ooh La La song also has been sung by Mr. Bappi Lahiri. A case was filed in Calcutta High Court seeking damages, saying that this Ooh La La song has become so famous that we also deserve credit for that and therefore the money. Now we went to Bappi Lahiri ji, we said that, sir, why did you make this big attempt of giving us the credit of the other song? So he said, I am issuing a certificate to you that both the songs are different. Now by issuing a certificate, you can't say, if you really want to distinguish between two songs, in the legal parlance, you distinguish between the notes of the song. This is the evidence, and there are certain laboratories and agencies which do that. We were asked by the Calcutta High Court, please deposit 2 crores in advance before the case is heard, and the case will take a lot of time, 5 to 7 years more. We were asked to deposit 2 crores as surety. We appealed that order. Fortunately, unfortunately, we had to pay 50 lakhs as surety in the courts of law. The case is still pending. Prima facie, I have heard the song, and you will not believe this was the scenario in the courts of law, but this is how things were to be. Both the songs were played in loud noise in the courts also. And the judge after that said that prima facie, I feel the songs are matching each other. Don't you feel so? So you have no answers to that, but this is what the scenario was. Prima facie, there is a good case made out. You find similarity in the notes of the song. We are fortunate that we have to only deposit 50 lakh rupees. Rest, when it comes up, the matter comes up, it will be taken on merits. This is the first example. The second example I am taking about intellectual property rights passing off is a very important judgment. This is a judgment you are getting after around 40 years. You had Dawn film which was made, you had Sholay which was made. They all tried and attempted for that, but they could not get it. What we went on a tangent in that is that we said that we are not talking about The Dirty Picture as a name of the film. Today when I create a brand name, I have nurtured that brand name, which means I have advertised, I have invested money in that. I have made it famous. The song has become famous. There are actors and actresses involved who have made this name famous. There are business world magazines which are rating that this particular name has become a good brand name. We also got some credit in Economic Times, Business World and all, that this name is becoming famous. We tried to show to the court that, don't take names of the film just saying that, okay, all right, these are names which are existing, you can't trademark that, you can't go on a tangent that, you will require this as an exclusively. So Dawn word is a common word, I can't give you an injunction because then nobody can use the Dawn word, etc. It becomes a mess in the judicial system. What we projected to the judge is that it's a brand name. Let us start recognizing the brand name because film names do make a difference. So what happened is that we gave the judge all the list of the brand names where this particular The Dirty Picture brand name was published. And we told the judge, because this has become famous, there are two people, producers from Canada, one from Canada and one from Calcutta, who are trying to make a film by using the name The Dirty Picture so that they can immediately monetize on this intellectual property right. Unfortunately for us, we served legal notices to both of them. The Kannada film producer went ahead, the Calcutta producer did not went ahead. We were more worried about the Calcutta producer because he turned out to be member of parliament. But fortunately, the issue did not go off from there. We filed a case against this Kannada producer. Immediately we got an injunction. We had Justice G.S. Patel, who is very good on intellectual property rights. Because we have a lot of matters of Raymond where people infringe, use the name Raymond, try to sell their products by the name of Color Plus, etc. And we get good injunction orders, including penalties if the person doesn't appear in court. She is a good judge on intellectual property rights. So we got an initial injunction in this case, a stay order. And then the Bombay High Court gave us a permanent stay order saying that this film name is the brand name of Ekta Kapoor and Balaji Telefilms, and therefore nobody else can use that. The Bombay High Court also directed the Film Registration Authority of Kannada to cancel the registration of the name also which they had sanctioned. So this is one of the landmark judgments. In future for any film name, this can be used. The another case law we have is about a film known as Lutera. What happened in this film was that everything was going great. Friday was the release date. Thursday morning we get a legal notice from a gentleman saying that the word Lutera, which you have been publicizing for last 15 days, that this is your film, etc. Sorry, you can't use this name. I have a registration from the registration authority. Now the problem is that while we give you a lecture that you should have all your registration in place, if you get registration of the association and somebody shows you that, what do you do in that scenario? We had one more situation in this case, that the registration authority also issued a letter to us saying that the Lutera name has been given to you, please use it. Now you have two letters individually to people saying that you can use this brand name. The association is then approached saying that the film is to be released tomorrow, you have created a controversy, please resolve it. They officially convene a meeting, write that this particular registration to the other gentleman was given 5 years back, he should have used it within a 12 months period, otherwise it lapses, and therefore Balaji has green signal to go ahead with the film. So this is one of the scenarios we had faced. But what we had done additionally is that we had already filed copyright applications and all that, which this gentleman had not done, so we had kept our backups ready. We have discussed about the intellectual property issues. I'm just reflecting from the perspective of a lawyer in an entertainment industry. Some 2-3 examples I'm giving you as a learning from the outside world. We had a film known as Shootout at Vadala. Now we had used the word Har chor Valmiki nahi hota. That means every thief is not a saint. Valmiki is a prominent community, and this particular dialogue is said by a police officer when John Abraham pleads to him that I have not killed the person as a murderer, I am an innocent person, and this particular dialogue was said. There were protests in a lot of places, especially in Punjab. Punjab I specifically remember because I got a call from the Commissioner of Police at 9 o'clock in the morning on Sunday that I am applying section 144 and I am stopping screening of the movie because there is a lot of chaos going on in Punjab. Okay. Now, when these incidents take place, the first reply what you give at the outset is that the censor board has given clearance, and this statement is said in the right sense. There is no implication to that. There is nothing wrong in the statement. The point is that you don't want to affect the sentiments of any community. Your censor board has given clearance to you. Now the only remedy which is left is that people can go to the courts and take a stay order, if at all. But stopping of a film is very dangerous for your revenue point of view because your film is now lasting for 7 days. If you stop the film on Friday, Saturday, Sunday, you're gone. So what we do is that immediately you activate your machinery. Now to remove this line and put a beep on every theatre in India is a time consuming process. Thanks to the technology, you can do it 80% now by sitting on a computer here. Balance 20% who still use that rail processor, etc. There you will have to send physically a distributor and you'll have to cut that particular part. So an undertaking was given to the community that as a good gesture, without going into the legal merits, as a good gesture, we are deleting that so that the film is exhibited. Right? These are the protests which are happening. Now, these are some observations which are made not relating to shootout at Vadala, but majority of the time we have seen that, when this protest etc. happens, these are sometimes publicity seeking. I don't want to use the word all times. But point is that, for example, in this shootout at Vadala only in some jurisdiction, we had issued an apology letter. Now, a lawyer's notice was served to us that you have offended the community, etc. Please tender an apology and therefore will then allow your film to be exhibited. So I called up the lawyer. I told him, all right, tell me what you want me to write. I am writing and signing and giving it to you so that the issue is closed. But be polite. So he says, write down in the first paragraph that a notice was issued to you by Mr. So-and-so, a well-wisher of the community, He has a practice in Punjab and Haryana High Court. He is a very well-known lawyer. And then you go to the second paragraph. So I told him, what should I write in the second paragraph? He said, that you write whatever you want. So these are not some good indications which we get from the profession at point of time. And that particular thing which I wrote was published in next day's newspaper. So, you get a wrong impression that, sometimes why the protests are about. This is one more example of a film, Ek Thi Dying, where the controversy erupted even without the knowledge or even about having a dream about it. What the controversy was about, and you'll also get shocked while sitting here. See, when all these films are released, the first show you keep it for the press. So you call the press guys for giving a review about it. You call the press, you invite them to the theaters, and you serve them with snacks, you make them see the movie, then they write a review about it. So these are all promotional exercises which happen. So the press promotion of this particular film was kept in Mumbai, in Goregaon, where Adlabs Theatre has a big theatre hall. It belongs to Reliance ADAG Group. So that particular theatre is in Goregaon Film City, where all the film shoots and the television serial shoots happen. So from the gate to that theatre, it's a 20-minute distance. So what we had done, because you have called a lot of press people, you can't have individual cars for everybody. So we had kept an air conditioner bus for them. And because this was a film, Ek Thi Dying, about horror, we had put up a banner, Bus to Hell. Somebody filed a complaint in National Women's Commission saying that this bus to hell means they are referring to gang rape in Delhi. Unimaginable. You can't even think about it. You have a bus in Bombay, you put a banner in Bombay, and somebody implies about an incident, very unfortunate, but, and you will not believe, I appeared before National Commission for Women, and I argued for 5 to 10 minutes, and I was quite sensitive and emotional about it when I argued, because this was very insensitive. The person thinking about it has a more problem than this particular activity. But without getting into it, the idea was that there was no implication to gain publicity on such an issue. The person who must have filed the complaint, in her best senses, must have assumed that this may be one of the promotion. But you can't go to that extent. The first argument which was given to National Commission for Women is that the film and the promotions are cleared by censor board comprising of 5 women out of 6. The second is that Balaji Telefilms is a company which is run by Ekta Kapoor and Shobha Kapoor, 2 ladies who have their highest respect in life, can't even beyond the stretch of imagination think about having publicity to that extent. Okay? But post that, National Women Commission has not called for any future hearing to us. You have the last example about Jodha Akbar. This particular serial has a controversy in a particular jurisdiction more, Rajasthan, because the belief is that there was no person like Jodha and Akbar existing. Okay? And you have to see, when you deal with these problems as a lawyer in intellectual property rights, these are socio-economic issues. You will talk to politicians, you will talk to influential people. You have to understand the sentiment about it. Everything is not about publicity. So there is a thinking that Jodha and Akbar never existed. Okay. So PIL was filed in Jaipur and Jodhpur High Court, which is Rajasthan High Court, Jaipur bench and Jodhpur bench. 2 similar PILs were filed. The first PIL of Jaipur High Court was taken up by the judge, by the Chief Justice, and we had presented lot of historical materials. We also had lot of historical discussions with the other side, who was an influential politician but a very learned person. So he showed us certain evidence through an historian. We showed him couple of historian evidence where he also agreed to certain facts. But what happened in this case in our favor is that two similar PILs in different benches of Rajasthan High Court, both presided by the same Chief Justice. So the Chief Justice initially did not pass any order. He got upset that this you are trying to do something wrong. You can't file a similar PIL in every High Court because then it looks to be ill-intended. So no stay was granted by the High Court. The films of the company were stopped. So Ragini MMS at that point of time was releasing part 2. There was some protest and we had to get police security. No stay was granted by the High Court. The cases are still going on. There was some complaint which was filed before the Broadcasting Complaint Council. The tagline which goes below your television said that if you have any problem you can complain to the authority. Justice A.P. Shah was there. He had dismissed the complaint. Still the PILs are lying. Fortunately, unfortunately, the sealer is now over. Okay. So, we have discussed in detail about intellectual property rights, the issues, the cases which are there. The cases do go on in the courts of law while your film and the television serial may get over. So therefore we always say that picture abhi baki hai because your cases are still in the court. Right? This is what I have to offer to everyone. Thank you.